Rahul Reddy, we're here live from Houston, Texas. Every Tuesday between 5 and 6 p.m. Central Time, Reddy Neumann PC does bring in immigration updates. Emily, what do we have right now with the new year coming, which is October 1st of 2020? That's a new year for USCIS. So what's coming on for the new year for USCIS? Any good news, any bad things coming up?
A little bit of both. So because we've talked before about how the family-based immigration visas or green cards that go unused from this year get spilled over to employment-based next year, which begins on October 1st, we are expecting to see at least some priority date movement for the October visa bulletin. Now, whether this will be the filing date chart or the final action date chart, and if it's the filing date chart, will we be able to use the filing date chart? Obviously, we don't know that for sure. We'll know when the bulletin actually comes out. But that does give us the possibility that a number of people who have been waiting for years and years to file their adjustment may finally be able to file it in the month of October. So that's the good news. At the same time, we have a fee increase that's set to take effect on October 2nd. And that does change how the adjustment of status fees are, so we'll talk about that. One of the main questions I'm getting quite a bit right now for people whose priority date might become current in October is what happens if I'm no longer with that company and my new company hasn't started the perm yet, or I don't have my I-140 approved yet. And lastly, we've talked before a number of times about the different regulations that Department of Homeland Security has planned on their regulatory agenda, and the OMB recently gave their approval for a regulation that might be coming soon related to biometrics, so we'll talk about that.
Emily, when the priority date becomes current, I want all the people to be aware that there was a requirement of medical need to be filed at the time of filing the adjustment of status. There's no compulsion requirement at this point of time that the medicals need to be done at the time of filing the adjustment of status. It can be filed later on, or it could be filed, you can take it to the interview when your adjustment of status, you will be called for the interview requirement. So that is a good thing, that recent development, the medicals don't have to be filed. So a lot of people do wonder, how much time does it take to collect all the documents, collect all the information? Most of the information that needed for the adjustment of status, you should have already had it at the time when you file a H-1B extension. Not much more information is required. There are some personal information required. 5 years employment history, 5 years address history. You need to know your mother's maiden name, your mother's date of birth, dad's name, dad's date of birth. Those are small things. Normally, when I deal with the clients, Emily, I don't file much difficulty in obtaining any of the information. If the client is cooperative and they can get the work done in 1 to 2 hours at the maximum, though. There are some hiccups that I normally notice when I file the adjustment of status, especially people coming from Indian background. They may not have the birth certificate for some people, especially for those people who are born way before, but recently I've noticed that that problem is not there. Or the birth certificate doesn't have the parent's name properly, or their name is not printed properly, their last name is not there. These are all small difficulties. You can always file with 2 affidavits from your fellow family friends that can sign it, and all that can be achieved in a span of 1 to 2 days at the maximum. If you don't have a birth certificate, or if the birth certificate is not properly reflecting the actual truth, and that can be rectified by getting the affidavits. Not a big deal. I have written an article, Emily, that I would recommend a lot of people that if they don't have a birth certificate, what to do. They can go to rnlawgroup.com and search birth certificate or birth affidavit. It's a good article. Being a lawyer in India and also a lawyer in USA, I know what the problems you face in India in obtaining birth certificates. So this article clearly illustrates, if you don't have a birth certificate, what you can do. There is a thing called non-availability certificate. You can get it from the municipality, or if you're born in a small town, Gram Panchayat, that's what they call in India, you can obtain from them that there is no birth certificate. That's going to be good enough for you. If you can get the birth certificate from the municipality or from the Gram Panchayat, that is good enough also. Now, if you don't have a birth certificate, though, they can give that there is not no birth certificate is available from Gram Panchayat or municipality. And if you can't even get that, there are still alternative things that you can do. But at all costs, though, is this going to create any problem in filing the application? No, it won't. I mean, if something is missing, we can still file the application. We can always rectify it at a later date. So that's the most difficulty that I faced. So now, obviously, when the priority date became current, Emily, it became current. You know that you were working at at our office at the time. The priority date became current all of a sudden in June of 2000, and for the July 1st, we had to file 500 family applications, and that too we came to know that they only accept applications on first date, not on the second day. So it definitely was a big problem for us, but we were able to achieve the target. We filed all the cases in the span of 20 days. Now, the most difficulty as I faced at that point of was the birth certificate and medical certificate. I already told before that we don't need it right now to file adjustment of status. And rest of all the information, I-94 passport, mom's name, dad's name, people should know that. I will be very surprised if somebody doesn't know any of the information. So all that can be collected in the span of 2 hours. I've also written a recent article that what are the documents required if you want to collect the documents and keep it together. This article is published today at rnlawgroup.com, and you can also make a consultation with me or Rebecca Chen in our office if you want to discuss further. Even if we did not file your I-140, we can file your adjustment of status. So you can contact us to file the adjustment of status. A lot of the bigger multinational company people, they're telling the employees to go and file the adjustment of status with their lawyers of choosing, and you can come to us to do the adjustment of status if you want us to do. Anything else to add on it?
Yeah, so most important things are start working on your 5-year of address history. Go back and look at all of those addresses you've had. Make sure you and your spouse have your employment history for the last 5 years. And then the other item is, obviously we don't know for sure if your date will be current in October, and some of these things do expire. So you want to make sure that if you're going to get your passport photos, they have to be taken within the past 6 months. So you can't use old photos. If your date doesn't become current in October and becomes current much later, you may have to get the photos again. So that could be something that you could wait until you know the date is current for. Medical exam, same thing. You can wait and get that done later. You don't even have to include it at the time of filing. And also the documentation, financial documentation. You have to include bank records, credit scores, health insurance proof. If you get all of that together now, it might end up expiring. So I think better to wait on a lot of those things. Know what you need to get, know where to get it, but don't get it all together right now until you know for sure your date's current.
Emily, you said the filing fees is going up for adjustment of status. Is that what you said?
Kind of. It's a
wait, Emily. Are you lying? I have seen in the USCIS website release recently that the adjustment of status fees has gone down by $50. So are you lying or the immigration is lying? Tell me the truth.
We're both telling the truth, I would say. They're doing this a little bit backhandedly. So correct, the I-485 filing fee itself is going to go down on October 2nd. The problem is the E-80 and advanced parole, the I-765 and I-131, those are currently free, and they've been that way since 2007.
August 16th, 2007.
So if you filed any time before now, you file the 485, you and your spouse and your kids even file the 765 and I-131, and you keep getting renewals every 2 years for free. There's no filing fee. That's going to change on October 2nd to where the I-765 is over $500 alone, and the I-131 is over $500 alone. So while the 485 filing fee is going down, the other filing fees are going to increase by over $1,000. So you may need to reconsider whether your kids are going to need that I-765. I mean, I normally file it for everybody.
Yeah, because it was free.
Exactly. So now if I have, a 5-year-old kid, probably doesn't need a work permit. We were just getting it so they could get their social security number more easily. But we may need to rethink that. And the same with the adjustment of, or the advanced parole. You need to decide whether that's really necessary. Do you really have travel plans? And be prepared for that extra $1,000 per person if you do decide to file those applications. And at the same time, every renewal, so when your priority date's current, you generally get a 1-year EAD and AP. If USCIS doesn't adjudicate your application in time and you have to file renewals of those, you have to pay the $500 plus fee for each application again a year from now. So that's going to be a huge
if
issue
there are a
for
family of
people.
4 members, you're keeping an additional $4,000 maybe up to every year.
Yeah.
So practically, I would say that you are telling the truth, not the USCIS, because they're telling they reduce of $50, but they're increasing $4,000 right now, and every year from now onwards until they get the green card is definitely an increase of our fees for the USCIS. Yes, when we were filing, as Emily was pointing out, that we were filing the 765s for 5-year-old kids to get an employment authorization, and also I-131, even if they have a travel plan or not, because you never know, things change. Previously, we did not even used to ask the clients, hey, do you want it? Because all they are providing is extra photographs, and that may cost them like a $10 to $15. None of our clients will mind that, so we don't even disclose that information that they're getting charged extra $15 to file a 765 and the I-131, because we didn't used to charge any money to file the extension, to file the 765 and I-131 along with the 485 application. But now, since the fees is there, every client we have to go through. Are you filing the EAD? Do you want this? Do you want this one? And that's going to be a big choice to make. So if the priority date becomes current, though, if they allow us to file an application on October 1st, because somehow the regulations are the new fees is becoming effective on October 2nd. If you file the application on October 1st, you may be paying $50 extra for adjustment of status, but you'll be saving, if the family of 4, you'll be saving approximately $4,000 every year from now onwards until you get the green card if you file on October 1st. On October 2nd, it's a totally different story. So please, that's the reason why we conducted this session, to give more importance to the documents what you need to collect. Please go to my website, our website at RN Law Group. It's a recently published article. Try to collect the information. You don't have to contact the lawyer, but collect the information, keep it ready, and you know where to look for the priority date. We don't have to educate. You're coming to our news section every week, so you know where to look into when the priority date becomes current. Emily, premium processing, is the premium processing fees going up, or what's the story?
Yeah, so no fee change in the premium processing, but they did sneak in a change to the premium processing program with this fee increase. So the fee remains the same, but the service is going to take longer. So instead of it being 15 calendar days as the processing clock for premium, now it's going to be 15 business days. So probably an extra week or more to get the decision with premium processing with the same old fee. And the other major change, particularly for H-1Bs, that also is just they're sneaking these things in there. A lot of people didn't realize it. For companies that are required to normally pay the extra $4,000 filing fee when they file a new H-1B petition, this would be companies with 50 or more employees and 50% or more of their employees on H-1B or L visas. They always have to pay a $4,000 extra fee when they're filing a transfer or a new petition. Now, this fee rule changes it to where every time you file an extension, that company has to shell out the $4,000 again. And that's something that has to be paid by the employer. They can't pass that along to the employee.
So that's $4,000 extra fees for every extension that has been filed for certain employers. Man, that's a lot of fees. But they didn't say that the H-1B, the fees is going up by that percentage.
Right.
In the statement, they said that it's only going up by 11, 12, 13, or somewhere around that. But in truth, the filing fees is going very significantly higher. Now, Emily, this question pops up now. If, especially for the people, when the priority date becomes current, is what if the priority date become current and the priority date, the I-140 is with company A, but I'm actually working with company B right now, and the company B has not filed a labor, not at a stage when the labor is approved. What are the options available for me?
Yeah, so the first option people want to know if they can do is, can I file my 485 with my current employer, employer B, that does not have the PERM or I-140? And unfortunately, that answer is no. So you have to either have your new employer file the PERM, file the I-140, port the priority date, and if the priority date is still current at that point, file the adjustment of status. So that may delay your adjustment filing. Or if your old employer is still offering you that job, they still have the intention to hire you for the same permanent position that they sponsored you for, and you intend to go back to work for them when you get your green card, it's possible only in that situation to actually proceed with the 485. That old employer does need to file a 485 Supplement J, and they sign that under penalty of perjury, confirming that they are offering you this job. It's still a valid, bona fide job offer. So the employer has to be willing to sign that to have it be submitted with your 485.
Emily, you're saying that the new regulations are coming, that it requires biometrics for everything. We already have biometrics when we get the visa. We get the biometrics almost done for, we get the biometrics for when they change the status, when they extend the status on H4. Now what else they want to do is the biometrics?
So let me first say that this is going to be a proposed regulation and it's not out yet. So the final version could be different than what we're saying right now, but we are expecting soon to have this proposed regulation, and then we'll have generally a 60-day notice and comment period where we can comment on the regulation, and then they'll go back and decide if they're going to finalize it. So this is all very preliminary, but some of the draft regulation was leaked to the media very recently, and it appears that USCIS wants to basically require biometrics for every single thing you file, for every single person filing, unless they decide otherwise. So that means I-129s, that means N-400s, that means I-131, I-765, I-539 is already there.
I-765 employment authorization too?
Yes, everything. And if you are being sponsored by a family member who's a U.S. citizen, the U.S. citizen sponsor will even be called in for fingerprinting.
Biometrics, oh. Oh, is it only fingerprinting or?
No, that's the other thing. They're expanding the types of fingerprinting of biometrics, so it could include retina scans, it could include voice, it could include DNA.
Really?
Yeah.
So every time you file any application, there's a proposal to do all these things?
Well, we don't know exactly. I mean, I doubt they're going to require you to give a DNA sample, knock on wood, to get an EAD, but they are definitely planning on requiring biometrics for everything that's filed. They're expanding it, so that all applicants, regardless of age, have to go in for biometrics, and then the types of biometrics they might collect are going to be expanded as well.
I thought the world has improved with the technology where they can read the eyes. It's going to be easier for them to get the thing, and now they're telling that they're going to go back to the DNA old system to recognize a person?
Well, I think the DNA is going to be more for family-based cases to verify family relationships, but definitely an expansion of what we're currently seeing. And they're basically saying, and by the way, when you file this application, you agree to come in for fingerprinting at any point in the future between now and when you become a citizen. So they could call you in even after the fact to get it done.
Let's go to the questions and answers, Emily. Venkata from YouTube has this question. There was a furlough. Will the furlough within the employer's organization, will it affect filing an I-140 application? Yes, there is a chance that it might affect your I-140 application. The reason is that the employer said no to the US workers, and now he's filing an application saying that he needs the foreign worker. So that definitely may impact your I-140 application.
Ram from YouTube wanted to know if the processing time for an I-140 amendment is any different from the original I-140 processing time. This is particularly for EB1C. So an I-140 amendment is usually required in a successor and interest situation where there's been a change in corporate structure, and the new entity that's going to continue to sponsor you has to file an amendment to document that they meet all of the requirements of a successor and interest. And the processing time is basically the same. It's as if you're filing the whole thing from scratch all over again. Even though you've been approved before, they look into everything all over again, so your education documents have to be submitted again. Everything that was submitted previously, they have to prove all over again. So no faster processing time simply because it's an amendment.
Vipul from Facebook has this question. H4 processing time in California used to be online April 2020, and they just changed to February 2019. How can they go back in time? Well, we call them as bureaucrats, and we call them as USCIS, United States Citizenship and Immigration Service. That's what they can do it, they will do it, they've been doing it. So what does that tell Vipul is that the statement that they made that the April 2020 was a lie all along. I mean, if that wouldn't have been lie, how would the processing time move from April 2020 all the way to February 2019? That's almost 10 months back. So we have noticed this very many times. The USCIS is doing it, not the first time. But this time it was a little bit odd. Instead of moving like a month or two, they moved almost like 10 months for the processing of the H4. So that is definitely, they are admitting that previously they lied online and now they are correcting themselves. That's what they're telling. What we would suggest is that if you have an EAD application pending though, I would request that you contact our office. Our litigation process is open right now, where we are taking people to the court to get their H4 plus EAD approved. If you're interested in, drop an email at info@RNLaw Group. We'll give you further information on that. We do have a conference call at 11 o'clock every single working day. That will address only the H4 and H4 EAD delays. So you can contact us, we'll give the information about that.
A couple of perm processing questions from Facebook. First from Rajib, he wants to know if there's a reliable website to check the status of a perm application. No, there's not. It's not like the USCIS website where you have your case number and you enter it in and you'll get the status. Only your employer or attorney can log into their perm account and look at the status of the case. Otherwise, it's not something that you as the beneficiary have access to. And Rajdeep wants to know how long perm approvals are taking and is there a higher chance of audit right now. Perm approvals, we're starting to see approvals for cases that were filed in April. So we're looking at 5 months approximately. We're not seeing any increased levels of audits right now compared to what we've been seeing in the past. Hopefully that doesn't change. But that does tend to change when unemployment is high, but we have not seen that trend yet.
Any predictions on the priority date movement? I'm not going to do it. Go back to my old statements on that. We definitely know that there is 60 to 110,000 green cards that will be allocated more than normal to the employment-based green card for the year of 2021 starting from October 1st. That has been confirmed by the State Department. With regards to how far the dates will be moved is going to be big speculation. We want you to watch the visa bulletin. Obviously, our news will be a little bit later because we all know that you subscribe to the visa bulletin. If you don't, you go to the State Department and sub bulletin, you will get it, and then we will analyze it in the following Tuesday when the priority date when the visa bulletin comes in.
Vikram from YouTube has an H-1B, H-4 and H-4 EAD renewal that was all filed back in February. The H-1 has of course since been approved, but the H-4 is waiting on biometrics. Now he's looking at the processing times for the EAD, and it's showing that for when his EAD application was filed, you could submit a case inquiry for the EAD application, and he wants to know, is that something that can be done? Can it be expedited? So unfortunately, the processing time when you've got an H-4 and EAD pending together is the H-4 processing time, the I-539. So even though the EAD may be outside normal processing time, if the I-539 is within normal processing time, which it likely is, you won't be able to do a case inquiry. To qualify for an expedite, you'd have to show that it's within the national interest, governmental interest, or humanitarian reasons tend to be, especially if your job relates to COVID-19, healthcare, something like that. Those are the ones that are most likely to be expedited.
Illa from YouTube has this question. I have an H4 EAD valid until, she didn't give the time, but I'm assuming, let's say in 2021, the husband has moved to a different job. Can she continue working on the H4 EAD? If your H4 EAD is still valid, even if your husband has changed the job, you can continue working on the H4 EAD. If the validity date is still there, you can continue. Absolutely no problem with it.
Santosh from Facebook wants to know about third country national processing for visas. So he currently has an F1 visa stamped in his passport, switched to H1B status and has that H1B approval, but has not gone for the H1B stamp yet, and wants to know, does he have to go to the home country to get the first H1B visa stamp? So the general rule is it's suggested, highly recommended for you to go in your home country anytime you're going for stamping, because those consular officers are more familiar with your documents. If they're looking at marriage certificates or birth certificates or education documents, they have more familiarity with that. And especially if it's something like an F1 or a B1 or B2 where non-immigrant intent is required, they're more easily able to look into your ties to your home country. However, the H-1B does not have that intent problem. It's a dual intent visa. Especially if you are here on an F1, you probably have a US degree, which means that it may be easier for you to go in Canada or Mexico if you can get an appointment there. So there's no requirement that you go in your home country unless there's a very specific situation that we're talking about. But of course, you have to get the visa interview or at least get the drop box scheduled, and all of that is still delayed right now.
Ballpark from YouTube has this question. I have an EB2 I-140 approved. My sibling is a US citizen. If they sponsor for the green card, will it affect negatively or positively for the employment-based immigration? No, it will not. The family-based immigration will not negatively or positively affect your employment-based green card. They both will go parallelly, they don't intersect, and that it is not going to harm you, it won't help you, but it's an alternative just in case if you're sometimes, who knows, the sibling family 4 category might become current than EB2. It could be possible. You won't lose anything for sure. You may or may not gain, but definitely you won't lose anything by having your sibling file an I-130 application for you.
Tajbir from YouTube filed an I-539 back in May, which is still pending, but also has an H-1B CAP petition pending. And now he's left the U.S. and received a fingerprinting appointment notice while he's outside the country. He wants to know, should he tell USCIS about the departure? So if the I-539 was requesting a change of status, then the departure is actually going to cause it to be automatically abandoned and denied. There's nothing to inform USCIS about that. If it's an extension of stay, the application can still be processed, but you'd need to get the fingerprinting done. If you don't tell them to reschedule and you don't show up for that fingerprint appointment, they will just flat out deny it. They don't give you another chance. So really what this boils down to is, what's your plan from here? If you ultimately are able to apply for the H-4 visa stamp and come back, then you don't necessarily need the I-539 to be processed. Or if you're going to wait outside the US and go for H-1 stamping, once that's approved, you don't need this I-539 to be processed.
SD from YouTube has this question. If the priority date becomes current in October of the or any month, do we need to file the 485 application in the first of the month or by the end of the month? Mr. Daniel from YouTube, you can file the 485 application by the end of the month. It doesn't have to be in the first of the month. The reason why we suggested only for the month of October, try to file on the first of the month, is that there is a drastic change in the filing fees from October 1st to October 2nd. That's the reason why we recommended to file in October 1st. In general though, it's not required that you must file an application in the first of the month. You can file within that month period. That means that if the priority date becomes priority date becomes current October, you can file within the month of October. But this exception, what Emily and I was pointing out, is just is just to avoid the extra filing fees that you'll be incurring. Amit from YouTube has this question. Will the priority date be current for EB3? There are some YouTube things that I have looked into, said by other lawyers. I'm not telling that they are wrong in any way, but I think so that has been completely misinterpreted. What the lawyer said in the YouTube was that the EB3 for the rest of the world is expected to be current. And I'm in the agreement with that lawyer that the rest of the world will be current. The rest of the world does not include India, unfortunately, and it does not include China, unfortunately. So there are some countries that are excluded in it. The rest of the world, because of the 7% cap for each country when the entire amount gets filled out. So we do expect that for the EB3, it will be current for the rest of the world, but not for Indian nationals and not for Chinese nationals. That is not our expectation at all.
Mohan from YouTube wants to know if there's any possibility for the president to use an executive order to stop those unused family-based green cards from being converted over to employment-based green cards for 2021. And is it possible that he'll extend the current green card travel ban beyond what it is at the end of December? So I think the good news is the president does not have the power to block those green cards from being moved from family-based to employment-based. That's something that's set in the statute. The Immigration and Nationality Act passed by Congress calls for that, and there's no discretion given to the executive branch to change that requirement. So I don't think we have any issues there. Now there has been several times where bills were introduced in the House that would stop that from happening because they want the family members to be able to actually receive their green cards. But those are just bills that are proposed. They've not passed or been signed into law, so that probably is not going to happen. As far as the travel bans being extended, I think that if Trump is reelected, you can be quite assured that they will be extended unless a court stops it.
Ram Singh from YouTube has this question. He has filed an amendment for the EB1C I-140. Is the processing time the same as the I-140 application? Because it's an amendment, should it take lesser time? And Mr. Ram, the processing time for the amendment is the same as the regular processing time. The good news Ram Singh is that if by any chance the priority date becomes current for you, you don't have to wait for this amendment to be approved. You can use the previous I-140 approval. You can use the I-140 amendment receipt notice, and based on that, you can file the adjustment of status. You don't have to wait for it to be approved. Gursimran
from Facebook already has an approved I-140 in the EB3 category with a previous employer and is about to file an I-140 in the EB2 category with his current employer. He wants to know if when the priority date becomes current, can he pick which I-140 to use in order to file the adjustment of status, or is it only the most recent that can be used? So it's more like your employer can pick. So it depends on whether the old employer is still offering you that job and is willing to sign and submit the I-485 Supplement J, then you could use the old employer's I-140 to file. If that's not the case, then only the new employer can support the 485 filing based on the new approval notice.
How long, the question from Madan is that how long it will take to reopen the retrogust case once the priority date becomes current? Madan, I would want you to contact the USCIS. I want you to raise a service request because your adjustment of status is pending for a long period of time. Depending on the officer, though, typically it may take about 2 to 3 months, but I want you to follow up with raising the service request immediately when the priority date becomes current. A lot of people, some people are saying that we predicted the priority date to become current. No, that is not right. We predicted priority date to become current only for the EB3 non-Indian nationals and other rest of the country, but not for Indian nationals. I think the person got it a wrong idea and keep on posting us. So please get the idea that for Indian nationals, for EB3 and EB2, we are not expecting the date to become current, but for individuals who have filed, their particular date is expected to move because it's in 2009 right now. We're expecting that to move. That doesn't mean that it's going to become current right now. There's less chance for it unless there is some drastic change done by the administration.
Praveen from YouTube previously filed a B2 extension for his parents 4 months ago. Of course, it's still pending, and now the time period that he requested is almost up. So he's preparing to file another B2 extension because they're not able to exit the country yet. So he wants to know if he should reference the pending I-539 anywhere in the new application. Yes, absolutely. You need to submit the I-539 receipt notice for the pending application so that they can see that your parents did not overstay their previous I-94 and they're in a period of lawful status right now.
Naresh has this question: is there any delay in getting the receipt notices for the H-1B extension and premium processing? Yes, we are noticing a significant delays in getting the premium processing receipt notices. You're speaking about August 24th, right now is September 1st. That is very, very, very common nowadays. Narsimha from YouTube has this question: can we port the date from EB2 to EB1? Yes, you can. He's saying that his company doesn't have a branch outside the country. How to upgrade to EB1? Well, that's going to be tough. There are 3 kinds of EB1. One is extraordinary ability. Normally, if you have an Oscar or Nobel Prize, they will automatically, we don't have to do anything. Just show them the Oscar Prize or Nobel Prize, they'll take you in. Or even if you get nominated to any of those things, there is a good chance that your EB1 will be approved. But there are other 10 criteria. So if you meet 3 of those things, you can. But they're very tough to meet. There is something called outstanding researcher that normally is reserved for the doctorates working in research field, but the company must file it. That is EB1B category. EB1C category, most of you know, is a multinational executive position where you go and work in a very higher level position outside the country for 1 year and you come back. Now, it's not that easy as people think. Oh, I'm going to go to India, I'm going to work there as a manager, and I'm going to come here, I'm going to get my EB1 approved. That is not that easy to get it done. Even if the company has a branch office there, there are a lot of things that you need to know before you make that move. There are a lot of denials from EB1, there are a lot of denials from L1A, there are a lot of requirements for it. It is not as easy as people think. If you plan to embark on the journey of going to EB1C category, I don't want you to take the journey before you consult a competent lawyer to get the evaluation done. What are my chances in getting the EB1C approved? When you consult a lawyer, you need to give the description. What is the proposed job description there? What is the title there? What is the structure of the office there? At what level you are in? And when you come back to United States, the same thing is applicable at what structure you are in. Those are very crucial to determine whether your EB1C will be approved or not.
Illa from YouTube wants to know if the H-1B spouse changes jobs, should the H-4 EAD spouse file a transfer of the H-4, or can they continue working on the current EAD until it expires? So you have the choice. You can continue working on your current H-4 EAD. It remains valid as long as you are maintaining H-4 status, which happens as long as your spouse is maintaining H-1 status, regardless of which company he or she is with. You may want to consider going ahead and filing the H-4 EAD along with the transfer, mainly because, one, you don't need it right now, and the processing time is so long that you'll be able to finally get that extended EAD period without losing your current EAD status. That's what we're having a problem with right now with these H-4 and EAD delays and the biometrics. People end up losing their employment authorization because it takes so long. You're in a good situation where you have the validity for enough time to where you can get the new one without ever having to stop working. So that's one reason why it might be a good idea to still file the H-4 EAD with the transfer, even though it's not mandatory.
Praveen has this question: what is the minimum credit score required for filing an adjustment of status? Well, Praveen, it's the totality of the circumstances. Credit score by itself is not enough. But I can tell you that based on the amount of filings that we do, the problems that we face, as of now, have you seen anybody in trouble in credit score, Emily?
No, but I don't think they've gotten around to those applications yet. Since
Yeah,
it's just
but
February.
mostly these are applicable to the people who don't come from the employment background, especially if your salaries are ranging more than 60,000 per year, which most of you guys in the IT profession have high salaries. Unless you have, unless you're a gambling addict and have done a lot of different things to destroy the entire thing, I would be very surprised if any of my clients or most of the audiences that belong to this Reddy Neumann channel will be into any trouble, because I guess you Praveen, I'm assuming that you'll make more than $60,000 to $70,000 a year, and on top of that, your family income, and also on top of that, I'm assuming that you are not a very big gambling addict that lost all the money and then not paying any of the debt. If my projection is right, most probably you should not have any problem.
Shubham from Facebook wants to know if the I-140 in premium processing can be returned back because of an electronic signature on the perm. So we did see this quite a bit, especially at the very beginning when they started accepting those electronic signatures. I feel like that was back in June. I had one case, I think I had to refile it 4 times. It was driving me crazy, but we eventually got it submitted, and they accepted it and approved it and all of that. So they are supposed to accept the electronic, not an electronic signature. This can be a copy of an original signature. Electronic signature is different, like a digital signature, that's not possible. But assuming you're following the requirements for the signatures that can be done now during the COVID-19 situation, they should eventually be able to get that accepted and processed.
Question from Yokita is from Facebook is that, is there any proposal for the premium processing for the H4 and H4 EAD? Well, there is a legislation passed in the House, which is the lower house of the Parliament, and that provision is there, but it's not going anywhere because it's not a bipartisan thing. So unfortunately, there is no premium processing that we feel that will pass through in the next 2 to 3 months. We don't feel that it's going to process in the next 2 to 3 months.
Anita from Facebook wants to know if a person travels outside the U.S. during the H4 and EAD extension applications while they're in process and the I-94 is expired, will the applications be canceled? So for an H4 extension, no, they won't be canceled. They can still be processed if you have the biometrics. The problem is if you leave and while you're outside the U.S., then the biometrics get scheduled and you're not able to come back to do the biometrics, that's where they can deny the I-539 application, which will then cause the EAD to be denied. So assuming that you have done the biometrics, if you then exit and wait for the H4 and EAD to be approved outside the U.S., that's fine. Or you can go for H4 stamping at the consulate if you qualify and come back and get the EAD once it's approved.
Emily, I want your attention on this question from Matthew from YouTube. If the priority date becomes current and if he moves from one state to another state, does he need to file a new permit, I-140, to file the adjustment of status?
Possibly. It all depends on whether the original job offer is still available. So are you moving temporarily right now based on your current non-immigrant status, and the permanent job offer that you'll take when you get your green card is still in the original location?
Emily, what if it's a consulting company that have they say that they will be working at unanticipated locations, which we normally, when we file the labor certification, we put that they could be working at unanticipated locations.
Yeah, if the unanticipated locations language is there, I don't see any issue. You can file the
So there are 2
45.
things. If the consulting company files a perm labor certification application, though, they normally, the lawyer must be stupid enough not to put that. They normally put that if you can work at unanticipated locations. So if the labor certification has that, which most of the consulting labor certification has it, if there is a change in the job, it will not affect in filing the 485 application. But as Emily has pointed out, that if it's not a consulting company, or if it's a consulting company and they did not put that the employee could be working at unanticipated location, then If it is outside, you were saying, what, Emily?
Yeah, if you're not going back to that original location and the new location is outside the metropolitan area, that labor certification is invalid and you have to get a new perm, file the new I-140. You can file it concurrently with the 485 if the date is still current by that point.
Kamal from YouTube has this question. His I-140 has been approved in 2015. Can his old employer withdraw the I-140? Now he's moving, after moving to a new employer. Kamal, they can withdraw the I-140, but it won't have any negative impact on your moving to the new company or extending the H-1B from the new company or moving to the third company from new company. So practically that I-140 withdrawal will not have any effect mostly. The only effect it will have is that if you want to get a green card through previous company, that may be a problem with that approved. But otherwise, to file the H-4EADs, to file the H-1B extension, to file the H-1B transfers, it is not going to cause any problem just because your old employer has withdrawn your I-140 application. The only thing that is needed is that the I-140 must not have been withdrawn within 180 days after it's been approved, and it must not have been withdrawn before January 17th of 2017. If both conditions are met, you are safe.
Shiva from YouTube is currently on L1A and has that visa stamped until January of 2021, but also got the extension approved until 2022. Wants to know if he travels and comes back before January 2021, can he use the existing stamp or does he need a new one? So I'm assuming that this is not a blanket L1, and in that situation, you can use the existing stamp to return before the expiration date of that existing stamp, before January. You do want to show your extension approval notice at the port of entry so that you can get a new I-94 to the longer extended period from CBP. Some people just show the visa stamp and no other documentation. CBP may only give you an I-94 until January 2021. So make sure of that. Now, if it's a blanket L, then you have to look into what date does the I-129S expire. If that is expiring in January 2021 or has already expired, that may require you to get a new visa stamp, even though the stamp itself is not expiring.
Krishna from YouTube has this question. Can I do the multiple jobs on H-1B with the same employer? Well, with the same employer, yes, you can have multiple clients, not a problem at all. Not a problem. This is commonly done. Your employer is the same. There are also situations, this is not for you, Krishna, but other people. Can one employee on H-1B work for two different employers at the same time? The answer is yes, if the second employer files a concurrent H-1B. That means that you work with company A for 40 hours, with company B, either you can work for 40 hours too, both companies 40 hours, or the second company can only file for 20 or 30 hours. You can do that. Naveen from YouTube has this question. Is there a premium processing for the 485 application? Unfortunately, no. There is no premium processing for 485 application.
Tejaswi from YouTube was recently selected in the second H-1B lottery, but it was with a previous employer, and that employer is not sharing the selection notice and is not willing to file the H-1B and wants to know what the options are. Unfortunately, there are no options. That selection notice is only valid for that specific employer, and if that employer no longer is offering you that position, there's nothing you can do with that selection notice. You'll have to try again next year.
Questions from the consulates are coming. We are noticing that the consulates are issuing the visas only for the people who have some emergencies, or mostly healthcare workers right now, but the slots are not open though. We do notice that the slots are open in February of 2020 for most of the consulates. We're also noticing that the student visa people are getting high priority in getting the visa status allocated though. That was until last month, but I'm not sure if this month they would get the priority because their college already started. So that's not the priority right now. Until August, it was a priority to give student visa people. Visa slots are not open until February in most of the consulates. Only for emergency things they are granting visas.
Mitesh from Facebook has an H-1B and has that valid visa stamp, but his wife has an H-4 and no H-4 visa stamp. He wants to know if she is eligible to go for stamping given all of the travel bans. So yes, she is eligible for stamping. The Department of State came out not too long ago and confirmed that if you are in the U.S. in H-1 status or have the H-1B visa stamp, your spouse is eligible to receive the H-4, assuming they can actually get a visa interview or the drop box.
A lot of people are asking for predictions on the priority date. Please, guys, don't make us tell wrong things. So please keep watching this YouTube. When the visa bulletin. What you can do at this point of time, what my suggestion is, go to website rnlawgroup.com. I put an article just today. Just try to collect all the documents, all the information as much as you can, and be watchful on the visa bulletin. It's very hard to predict the visa bulletin. Believe me, I told you 100 times. I went 1,000 times wrong in predicting. And I can't tell you, I don't want to be going 50,000 times wrong in predicting the priority date wrong. So please don't make me, do it 50,000 times wrong things.
Gaurav from Facebook has an employer A who filed the H-1B extension along with the H-4 extension for his spouse, but then he also filed a transfer to employer B, which has been approved, and he joined company B, did not file an H-4 with company B. He wants to know if he should file the H-4 extension with company B. I generally would recommend it because with company A's case still pending, there's a good chance that company A may withdraw that pending case because you're not working there anymore. The withdrawal of that case could lead to the denial of the H-4 that was filed along with it. So for that reason, I probably would file the H-4 with the new employer.
Prem has this question: can I file an EAD application while the H-4 extension is in process? Yes, you can file the EAD while the H-4 extension is processed. You can attach the receipt notice and file for the EAD. Absolutely no problem with it. Some questions are coming with regards to H-4 EAD filings. My H-4 EAD is expiring in 2021, but my husband's H-1B is now, because he moved to a different company, is expiring in 2023. Can I file for the H-4 plus EAD right now? The answer is yes, you can. There is some provision there in there that they could deny if you file more than 6 months, especially the EAD. But we have not seen a single denial when the EAD application has been filed by more than 6 months. They could deny in future. We will inform you. But I would strongly, if I were you, they're taking a long time to adjudicate these applications. I would file the extensions as early as possible. So in your case, you could file for the EAD, H-4 and EAD right now.
Chinmay from YouTube wants to know about passport validity and H-4 extension and EAD extensions. So his planning to file the H-4 extension and EAD extension soon, but the passport's set to expire in October. He wants to know if there's going to be a problem because the passport is expiring. So when you're filing with USCIS, it's okay if the passport expires after you file. You just have to show that at the time of filing you had the valid passport and that you are getting the new passport before the current one expires. Where the passport expiration becomes an issue is if you are traveling. So if you were entering the U.S. on H-4, at that point they normally do cut your I-94 short based on when your passport is expiring, not when your H-4 is expiring. And that creates a problem for people that aren't aware of it and don't file the extension in time. But with USCIS filing, no issues with the passport expiring soon.
Even though this is a live recording, guys, this video will be available forever. So you can go back and look into the things what we have commented, especially, we do see a lot of repeated questions. We already answered it. So if you would listen, most of the questions are answered. So go back and listen. You will find the answers for most of the questions that you're posing.
Lokesh from YouTube wants to know, what are your options if you get a 221G? How can it be expedited? Unfortunately, once you get a 221G, there aren't really any options to expedite it. It just has to take its sweet time, and it all depends on what the issue is. Sometimes 221G can refer to a security check that can take a long time to process. If you're working for a consulting firm, a lot of times at 221G, they're doing a fraud detection, where they're going back to the end client where you were placed to make sure that the end client letter was actually valid and there's no fraud in those documents and that job is still available. If you've previously been on F1, sometimes administrative processing can involve a SEVIS check, where they go back and look into your SEVIS history and make sure that you didn't violate your F1 status, even if you're not applying for an F1 visa right now. So there's lots of different things that can cause administrative processing, but once it happens, there's really no way to expedite it. There is no expedited processing. You just have to keep following up, keep checking the status every 15 to 30 days, depending on how long you've been waiting. Some of them, it can take 8 months or more. It's a long process for a lot of people.
Questions coming out with regards to the H4 EAD, how long this H4 EAD is going to be there, because especially the administration wanting to take off the H4 EAD. Emily, do you have Emily is preparing to file a court litigation if they would take the H4 EAD off. When the DACA EAD has been taken off, there are people who went to the court, have been successful. And Emily has worked on the H4 EAD just in case if the administration decides to take off the H4 EAD, which they already clearly mentioned that they would. What are you doing on it, Emily?
Right, so we've actually created a nonprofit organization called Save H4 EAD, and we're using that currently to raise awareness of the issue, try to get more information out into the media that this is going to be a problem, explain to people what the benefit of the H4 EAD is to the community, to the country in general. Why do we need it? Just for to raise awareness. That's kind of the first step in advocacy efforts. At the same time, we're planning on conducting surveys and research so that we can have the data to back up the reasons why we need to keep the H4 EAD, because at this point the Trump administration is saying they're going to get rid of it, but they haven't given any data to explain why they need to get rid of it. How is it harming U.S. workers? How is it impacting the economy by keeping the H4 EAD? So we want to be prepared with that data so that when they do come out with this proposed rule, we'll be able to submit it for the comment. So we'll certainly have draft comments available for you to submit as well. And then if they finally proceed with a final rule to eliminate it, we'll be ready to take it to court.
Questions from Abdul has this question on downgrading from EB2 to EB3 from Facebook. Abdul, I would recommend that there is a YouTube and Facebook video that we presented just about a week back. Please watch that. That only addresses between EB2 to EB3. When is a good time to downgrade it? Certain times, if the priority date is not current, though, we don't recommend you to downgrade it. You can always downgrade it at the same time, file the adjustment of status. You don't have to do it in advance. What you need, Abdul, is that you must have the consent of the employer. The employer has to file the downgrading. You need to check with your employer and employer lawyer. Are they willing to do it? If they will be willing to do it, then if the priority date becomes current, you will have 40 days to collect all the information, and mostly not much information is required for the EB2 to EB3, but you would need information for the adjustment of status. You can file the EB3 and adjustment of status at the same time. For further questions, I would strongly recommend you go and look into the video that we presented 6 days ago. Anything else, Emily?
I'll take one more. Alesh from Facebook recently applied for the H1, H4, and EAD renewal. His wife is currently working with the H4 EAD. He wants to know if she has the option to go for H4 stamping in Mexico once the H1 is approved. So possibly. Again, it kind of goes back to the biometrics issue. If she is able to get the H-4 stamp and then come back in H-4 status, that H-4 extension can continue to be processed, and that can be approved and the EAD approved at the same time. However, the downside is if while you're outside the country you get that biometric appointment and you miss the appointment, the H-4 extension can be denied, and that can lead to the EAD being denied. That means when you come back in with your H-4 stamp, you may have to refile the EAD. So you have to be real careful about travel in the current environment because you may not be able to get back in time for the biometrics.
Thank you very much for tuning. Don't forget that to subscribe to the RN Law Group website news section, and also Immigration Girl blog, which Emily manages it, which she updates it anything that is required. Any updates that come in, she updates it, I don't know, within 2 minutes. By the time I look into the headline, she already published that article on that. So try to subscribe to this news section, follow us every week, and so that you get the update from immigration.
All right, thanks for joining us. We'll see you next week.
Thank you.